Do we kick off, Emma?
Okay, super. Super. I was going to say, so firstly from Juice, we'd love to welcome everybody here today, won't we, Ali?
So good morning, everyone. I'm Alison Watson from Juice Recruitment, and I'm joined with Emma Summers, our CEO and founder. My role is that I'm head of client services for the Bath, Bristol and Cheltenham area. Really looking forward to our joint HR session here with RWK Goodman this morning, with Tim, Rich, Olivia and the team, and looking forward to hearing all about restructures, the case law updates, and of course at the end, as usual, there'll be a Q&A session, so feel free to write down some notes and some questions that we can look at through the end of the session. Over to you, Rich.
Yeah.
Tim.
Thank you very, very much. Morning, everybody. It is fantastic to see so many people on the call today. So what are we going to be talking about today? We're going to be talking about restructures, redundancies, and a case law update. So it's going to be split into 3 sessions. I'm going to be doing the first one. That is going to be looking at the recent case law that has an impact on restructures and redundancies. My particular favourite is the Mothercare case, the last one I'll be talking about, where Mothercare were found to have discriminated against a woman on maternity leave. Not great PR for them. Then I'm going to hand over to Rich, who's going to be looking at the Employment Rights Bill and parts of it that will impact on restructures and redundancies. And he's also going to be picking up a couple of other points about general legal changes around the redundancy process. When Rich is done, he'll be handing over to Olivia, and Olivia will be talking about some common immigration issues to consider when a business is going through a restructuring process, because it's a really important part of the process and something we must get right. As Ali said, thank you for raising it, Ali. Please do put your questions in the Q&A function as we go along, and we'll pick up them in a Q&A session at the end. We are recording today's session, and we will be sending some stuff out afterwards, which we always do after the HR Hub, which is a summary of what we talked about, and you know, a little bit more detail about the cases we're talking about. So just to jog your memory, and we'll also be sending the video out again. So if you have colleagues or people you know who couldn't make today and they want to see what we're talking about, please feel free to forward that video onto them. Okay, I'm going to kick off with a quick poll. I love running polls because it gives us a feel as employment lawyers about, you know, how our clients and how other businesses are doing in the environment. And I think it's useful for Juice to see that as well, because as a key recruiter in the area, they like to get a feel of what we, you know, how recruitment is. So Nicole, can we run question 1, please, of the poll? Okay, if you could just take a few seconds to look at that and to let me know your thoughts on that. That'd be really interesting. That's really good. I'm really pleased to see lots of positive there. I think when we started the year, there was a lot of negativity. I think as the year's gone on, there's certainly more positivity coming into the workplace. So there are clearly some businesses that are taking a neutral, let's wait and see type position at the moment. About 36% of those people on the call said that. Only about 9% said they thought there was a negative prospects for this year. That's wonderful. That's really wonderful. Okay.
Just to tap in on that, actually, just really quickly. Yeah. It's been really interesting, I think, when you're looking at sort of recruitment and trends, because we saw at the beginning of the year that it was very busy in January and February. And even though we all knew the implications of the costs with regards to the NI and the increase in minimum wage, I do think it actually tampered confidence across March and April, and that's what we saw. But actually, ironically, May's come back really, really strong. So I think it's very indicative of that confidence in the market and how people are feeling, you know, and actually that will very much sort of look at how they buy talent, fundamentally, the confidence to buy talent.
Wonderful. Okay. All right, so let me now start on my session, a bit of a case law update relating to redundancies and restructures. I'm going to talk about 4 cases today. The first case is the case of Mr. DeBank Haycox and ADP RPO UK Limited. This was a Court of Appeal case. So it was a relatively straightforward redundancy exercise. So Mr. DeBank Haycox was involved in that exercise. His job was at risk. Before we kick in, let's remind ourselves what the principles of a fair dismissal are. So a fair redundancy dismissal is where in all the circumstances of a case, an employer has acted reasonably, taking into account its size, its administration resources, in treating that redundancy as a fair reason for dismissal. That's a case called BHS and Birchall, which is your go-to case if you ever want to see how to do a fair redundancy dismissal. It's referred to in most cases, and it gives you a really good breakdown of what you should be looking for as a starting point. This case also involves collective consultation for redundancy. So as a reminder, when we're looking at making 20 or more employees redundant within a period of 90 days, we must be thinking about collective consultation as well as individual. Okay, so Mr. DeBank's Haycox was one of 16 staff at risk of redundancy. He argued during the redundancy consultation process that he had not been given his scores during the redundancy consultation process, and the company simply came back and said, yeah, that's right, we're not hearing any more on that, closed it down, wanted to move on. As we'll see, that was a big issue. So he was made redundant. Not surprisingly, very aggrieved gentleman raised a claim in the Employment Tribunal for unfair dismissal. He actually lost at the Employment Tribunal, so he appealed it to the EAT. And the EAT considered a number of points which we can pull out of the judgment that are really useful guidance for us as to how we're doing a redundancy exercise. Interesting to note that one thing the EAT said in its judgment was that organizations must put in place general workplace consultation. So effectively, the EAT was deviating from the established rules that we know about, okay, is there 20 or more staff, then we must put in place collective consultation. The EAT went on further this and said, in all cases, companies must put in place this collective consultation. So they said the dismissal was unfair, and they sided with Mr. DeBank's Haycox. Now, interestingly, that decision that all businesses must put in place this general workplace consultation, this collective consultation, was a decision taken by the EAT off their own back. It wasn't actually something raised by Mr. DeBank's Haycox. So not surprisingly, the business appealed to the Court of Appeal, because in employment claims you miss out the High Court and you go straight to the Court of Appeal. So yeah, the company appealed to the Court of Appeal. 3 key points came out of the Court of Appeal decision. And the first one is that to the relief of employers, there is no requirement for non-unionized employers to conduct general workforce consultation in relation to redundancy situations concerning less than 20 employees. So effectively, there is no obligation to do collective consultation. It effectively slapped the EAT on the wrist and said, yeah, this is crazy. This is an issue for Parliament to address. If they have issues about that, they need to change the law. So the law is what it is, and there is no obligation on businesses who are making less than 20 people redundant, do collective consultation as well as individual consultation. But what it did say was, it reminded employers that there is still an important point to consider in individual consultation, and that is employers must consider the workforce level type questions that come up as part of consultation. Those must still be addressed in one-to-one consultation in addition to the individual issues that an employee raises about their personal circumstances. What do I mean by this? Well, I mean those issues such as, why the company is proposing to make 10 redundancies in the sales department on what it is. What are the business decisions and the business's impetus that has made the business decide to actually make those redundancies? So we must still pick up those in individual consultation, and we must still ask the individuals, do you have any questions on why as a business we are deciding to make these changes? And you must still listen to what the individual says, and you must still respond to it. The second point the EAT said was that it made some clear observations about at what stage of the process consultation must start. The first thing it said was it must start at a stage when an employer still has this open mind. And this is really key. Because if an employer goes into a consultation process with a closed mind, there's not going to be any constructive consultation two-way about how the redundancy can be avoided. And at the end of the day, that's what we're looking for in consultation. Can we avoid redundancies? Often we can't, but as employers, we need to be seen to be taking those issues into account and looking at them. So it said that consultation must start at a formative stage. It's not when plans are still being discussed and nothing of any concreteness has been put forward by the company. But redundancy consultation must start at that formative stage. So the employer must still have an open mind at that time when consultation starts. And the employee must have the expectation of having a reasonable expectation of influencing the outcome. So putting stuff forward to the employer and expecting a fair response, and having an expectation of having a good two-way chat about how those redundancies could be avoided. And then the nub of it really is the later in the process that consultation takes place, the greater the risk that an employment tribunal will take the view that the employer has closed their minds. And if you get a closed employer, there's a good chance that's then going to lead on to redundancy consultation being seen as a sham and an unfair dismissal. It also emphasised that an appeal is a really important part of any process. Now, in this case, the business royally messed up the consultation process itself. It didn't give Mr. de Banks-Haycock time to comment on the scoring. Any good redundancy consultation process should do that. It didn't do that. But what they did do well, thankfully for them, was that they give Mr. de Banks-Haycock the right to appeal. He then put forward a very comprehensive appeal, and thankfully in return, a new officer of the company who wasn't involved in the redundancy went through that appeal comprehensively, looked at each of his points, and actually came to the conclusion that, yeah, we see that we might not have handled this well to begin with, but I've reviewed the situation, I've reviewed the whole redundancy, and I've given it what the EAT called, the Court of Appeal called conscientious investigation. And the appeal officer found that overall, there was still a fair process and there was still a fair decision reached, even though some of that process at the time of the redundancy consultation was not great. So remember, always have an appeal in a redundancy process. They're not get out of jail free cards. In some cases, you will have to go back to the process and may need to do it again if you can't remedy a defect on appeal. But in cases like this, you can actually reverse what was a wrong process and avoid potentially ending up in tribunal at a later date. And if you end up in tribunal, appeal can get you out of sticky water. So Mr. de Banks-Haycock lost in the Court of Appeal. Rich will be talking a little bit more about collective consultation and the Employment Rights Bill a little later. So Nicole, can we now pull up questions 2 and 3 from the poll, please? The answer to question 1 coming out is really interesting and really positive. I think it links with the first point, which is businesses are starting to see this year as more positive now, because only about 1/3 of people who are responding are saying we're actually putting recruitment on hold, and 2/3 are saying no, confident going forward, we're recruiting, which is really great. Question 2, what are the key drivers of your HR strategy? Good mixture there, actually. 10% national insurance increases. Yeah, a lot of companies have been completely walloped with those. They are significant changes, and we're having to make significant adjustments to factor in those national insurance changes. Employment law changes about 20%. Yeah, there's a lot coming down the line. The Employment Rights Bill is getting bigger. Rising costs about 20%. Technological changes only about 10%. Culture 25. That's a really interesting one. We're seeing a lot of people talking about culture and how we can embed it, change it. Other 21%. If anybody's got any particular others, please feel free to put it in the chat. I'd love to see what your other drivers as to your HR strategy are. So at some point, put it in the chat. That would be marvelous. Okay, so moving on. Second case, pre-termination negotiations. Now, this is a case of Mr. Gallagher and McKinnon's Auto and Tyres Limited. This is a case that made its way to the EAT back end of last year. So I know pre-termination negotiations better as protected conversations. Some people use different names, but I call them protected conversations. So a reminder of what a protected conversation is. It's a bit like a without prejudice discussion. And I got a lot of clients who use them for simple performance, redundancy, or misconduct scenarios. But importantly, we don't use them for situations where there's a risk of a discrimination argument. They're really useful because unlike without prejudice discussions where you need a dispute between the parties, you need a grievance, you need a complaint, you need an employment tribunal claim. With protected conversations, unless it's just a simple performance or a simple redundancy or a simple misconduct scenario, you can introduce protected conversations and know that a tribunal or a court will not be able to get behind the veil of that conversation. So Mr. Gallagher was in a redundancy process here. As part of that process, his employer had a protected conversation with him and wanted to offer him an enhanced redundancy package. It's actually quite common. It's quite common because if you can avoid the need to do redundancy, potentially you might be able to, spare other people the time and inconvenience of going through that redundancy process. You can put other people at ease of redundancy. So there is a time and a place for protected conversations. This company had a chat with Mr. Gallagher, offered him an enhanced redundancy package subject to him signing a settlement agreement, but he said no. He rejected the offer. Protected conversation stopped. Redundancy process started up again, and he was found. He was in a redundancy situation. He was made redundant, and he put in a claim of unfair dismissal. Now he sought to rely on parts of that protected conversation in support of his claim. So not surprisingly, the first thing the lawyers for the business did is said, they're protected. Take them out of your employment tribunal claim. I don't want the tribunal to hear about it. I don't want anybody to hear about it. This made its way to the EAT on appeal because he lost. It went to the EAT, and the EAT gave us some really valuable insights into protected conversations. There hasn't actually been a lot of case law about protected conversations, so we're starting to get some now, which is really good. So the first thing the EAT said is when we look at a case about protected conversations and whether we should allow discussions into tribunal proceedings, we look at whether there's been undue pressure on an individual by a company. Okay, they don't like the individual to have been pressurized into taking a settlement agreement exit. And they also said this is not a test of fairness when we're considering whether we should lift this protective veil, but we're looking at impropriety. Okay, so the first thing the EAT said was there's a big difference between staying in a protected conversation. You will be made redundant if you don't accept this offer, versus it's up to you whether you accept this offer, but if you don't, the process will start. So they don't like threats. That will be seen as undue pressure. Interestingly, in this particular case, Mr. Gallagher was off sick when the redundancy process was taking place. He attended what he thought was a welfare meeting, but the company turned it into a protected conversation meeting. And surprisingly, the EAT actually said, well, it may not have been fair, but we don't think it was improper to do that. On the facts of the case, the meeting, even though it was a protected conversation and not a welfare meeting that he attended, was conducted well, and it wasn't considered to be undue pressure in terms of what was discussed with Mr. Gallagher. So the EAT said that was fine. No, it was supposed to be a welfare meeting. You turned it into protected conversation. You do it well. You treat it nicely. You don't put unfair pressure on an individual. We will still accept that as being a proper protected conversation. And the EAT said setting a 48-hour deadline for acceptance that was verbal was okay. They reminded us that, okay, once we sent out the settlement agreement, once an employer said, yes, in principle, I'm happy with the terms, somebody gets 10 days from that to take legal advice. But in terms of saying, I'm going to give you a verbal deadline of 48 hours to come back to me and say whether you're happy with this or not, that was okay. So the crux of this was the tribunal and the EAT are really concerned about how we handle protected conversations. Are we overbearing? Do we put pressure on somebody? Do we put that undue pressure on them? And if we do, then we may lose that protected conversation veil, and what we say in that discussion may then be allowed in the tribunal. Okay, Nicole, can we launch questions 4 and 5, please? The last questions today. Ooh. Is your business considering a staff restructure redundancy exercise? This is a pretty close one. This is a bit Brexit. Actually, it's really interesting. So it's 57% yes, we are considering staff restructures, redundancy exercises. 43% no. Okay, so there's clearly a lot of change in our workplaces. And when are you planning to implement any staff restructures and redundancy exercises? Now 22%, later this year 21%, next year 4%, undecided 6%, 16%, and 40% said we're not planning one. Okay, so as businesses, there is clearly a lot of change still coming. Right. Okay, fantastic. Really useful insights. Thank you for taking part in that poll. I hope you found it useful. We really do as employment lawyers, and I know Juice do as well. Okay, I've got a couple of final cases to put forward to you. The next one is a case of Mr. Norman versus Lidl. Okay, so he claimed unfair dismissal as part of a redundancy process. He also claimed indirect age discrimination. Now, indirect discrimination is where a business puts in place a provision, criterion, or practice, a PCP, and an employer says that's indirectly discriminatory. Okay, so he was a senior construction consultant. Lidl wanted to go from 3 consultants to 1. These were the people that helped them find new, places to build on and then build those premises. The 2 other people in the pool with him were in their 30s. He was 63. He found out during the process that he was marked down on what the business called knowledge criteria. It was one of the selection criteria they used, knowledge criteria, and he was marked down because he didn't have a degree. So he challenged the scoring in consultation, and he was told point blank the scores would not change. Now, it's not the main thrust of this case, but to be that black and white about not considering somebody's challenge in relation to score is likely to find yourself in tribunal. It's likely to trip you up. There always needs to be flexibility in process. If a question like this comes up, we need as employers to be ready to adapt our process to look at things like that, and hear what an employee is saying, and potentially make questions about provisions, criteria, or practices, and in this case, those selection criteria. And as we'll see, if Lidl had actually listened to what he said and said, right, we'll strip out the degree question, they probably would not have found themselves in a tribunal. So this went to a tribunal because, not surprisingly, Mr. Norman was not happy. The tribunal found that Lidl hadn't actually scored him negatively on the actual skills in his role compared to the skills that other candidates had. And they did actually find that they hadn't used the degree as the defining criterion to say what his skill sets were. So if it had been left at that, and he hadn't raised an age discrimination claim, the tribunal would probably have found that this was a fair dismissal. However, he did raise an age discrimination claim, and he raised it on the basis that I'm 60 years old, and less people of my age will have gone to university and will have got a degree. This is where he fell down on this particular case, because the tribunal found that to implement a criterion such as have you got a degree when we're considering whether or not somebody has the skills to do a particular role and marking them against that was indirect age discrimination. Now, stupidly, what Lidl didn't do was to plead, first of all, that we didn't discriminate against this individual on the basis of his age, but they also didn't plead that there was what's called an objective justification to why they put that provisional criterion of practice into the selection matrix. I happen to think that they should just have stripped out the requirement for somebody to have done a degree, because if they had taken that out and just assessed Mr. Gallagher and his two others on the basis of the work they'd seen them do, they probably would have come to the same conclusion, because they had 23 years of seeing how Mr. Gallagher worked, and the other two individuals had been in the business quite a long time. So there was enough to go on. They didn't need to say, had you done a degree, and if not, we'll mark you down on that. They had enough information when it came to appraisals, one-to-ones, general observations of these three people. And so, a smart company would have said, right, degrees are relevant. It is related to age. Take it out. Just assess them on the basis of actual knowledge we've got of their performance. So they lost the indirect discrimination claim, and they had to pay Mr. Gallagher, I think, about £60,000, including some money for injury to feelings. So an expensive mistake that could have been very easily remedied by Lidl thinking at an early stage, right, the criteria we're using, is there any discriminatory element to these? If there is, take it out. Look how we can assess these individuals on a better basis that's non-discriminatory. And they probably wouldn't have found themselves in an employment tribunal. The last case is that of Miss Osborne and Mothercare Global Brand Limited. Now, Mothercare does still exist. It sells stuff to Boots. Now, the irony of this case won't be lost on most people. The irony of a mum who was discriminated against by Mothercare based on her maternity leave winning a case is not great PR for Mothercare. She was a technical manager in Mothercare. Shortly before her second maternity leave started, she said to the business, okay, you're going to put some temporary cover in place for me. They said no. She went on maternity leave. Lo and behold, very quickly, they did bring a consultant in. Now, that consultant was a pal of the newly appointed chief product officer, who Miss Osborne reported to, this chief product officer and the consultant had worked together at Mamas and Papas before. So she wanted to bring her in. So just before the maternity leave came to an end, the chief product officer started a restructure. And in that restructure, many of Miss Osborne's responsibilities were reassigned to other people in the business. But importantly, there was no consultation with her about those changes. Now, it's crucial not to forget somebody who's on maternity leave or sickness absence and consult them about what is happening. You can make somebody on maternity leave redundant, but you have to be very careful, and you have to make sure that you don't treat them any less favorably than somebody who's actually in your business and at risk of redundancy. When she came back from maternity leave, she was told her role was at risk of redundancy. She was encouraged to apply for a newly created role, but stupidly, that new role was very closely resembled to her old role. She was encouraged to apply for it, but she quite rightly said, "This is a sham. This is discrimination. I'm not going to apply for it." She was made redundant. She took a claim to the employment tribunal, and she claimed unfair dismissal, but she also claimed unfavorable treatment because of maternity leave under Section 18 of the Equality Act. Now, unfavorable treatment under maternity leave, this is where we're dealing with unfavorable treatment, not less favorable treatment, as we see in other areas of discrimination law. Because it's unfavorable treatment, no comparator is required, and an employee only has to show a disadvantage or detriment they have been subjected to by their employer connected to their maternity leave. So this is actually quite a simple decision for the employment tribunal to come to. It found very simply and very quickly that there was no contemporaneous emails or other documents to justify the argument they were putting forward in tribunal to explain why Miss Osborne was chosen for redundancy. There was very little coherent evidence put forward by witnesses at tribunal. And in the absence of that evidence, it was pretty easy for the tribunal to say that this had effectively been a manufactured redundancy to effectively bring a buddy of the chief technical officer into her role. The unfavorable treatments that the company found against Mothercare were, number one, the changes made to her role during redundancy were not discussed with her, unfavorable. Number two, she was excluded from discussions about her future role during maternity leave, and the timing of the decision to make her redundant was also seen as unfavorable treatment. From the evidence, the tribunal made a very quick determination that the decision had been taken while she was on sick leave without any involvement from her. So the key points we take here, as a business, we must always challenge the thinking of those driving change. Here we had a boss that was driving this through with an agenda. He wanted to get somebody out to get her pal in. And we must almost keep contemporaneous evidence of decision-making processes that we make so that we can rebut any challenges by employees or the tribunal if we ever get challenged on a decision we've made to make a redundancy or a decision we've made as to why a particular individual is in a pool, or we've rejected a particular point somebody's made as to why they think they shouldn't be redundant. So some lessons there from 4 key cases. Hopefully those were useful. I'm now going to, actually no, I've got some further questions actually. Nicole, have we done all the questions? I think we have, haven't we?
Yes, we've done all the polls now.
Marvellous. Okay, I'm going to hand over to Rich, who's going to talk a little bit about the Employment Rights Bill and some other laws affecting redundancy. Thanks very much.
Thanks, Tim. Plenty of redundancy case law around recently, so that was really interesting stuff. Yeah, Employment Rights Bill. So it's obviously an enormous piece of potential legislation, and so I'm just going to focus on a couple of bits really that relate to redundancies and restructuring. Unfortunately, we still don't have all the detail that's going to sit behind and help us really figure out what we're going to need to do when these provisions come into effect. So that's going to happen once there's more consultation over the course of the rest of this year. We also don't have any actual dates when anything is going to come into force yet, although I did hear a very well-respected employment law commentator a couple of days ago say that the fire and rehire provisions might potentially be in force as early as Christmas this year. I haven't heard anybody else say that. It's more likely, I think, that a lot of these changes will come into force in 2026. But, you know, we're not far away from halfway through 2025. So, you know, time will fly and these things will be upon us soon. So let's have a little look at collective consultation. There's one big change that or a couple of big changes I want to flag. So Tim mentioned earlier collective consultation. I'm sure we all know that if an employer is proposing to dismiss 20 or more employees for redundancy within a 90-day period at one establishment, so it's a key phrase there, then the collective consultation obligations will apply. Now, what the government's original proposal under the Employment Rights Bill was that they would take out the words at one establishment. So in other words, if an employer was going to make 2 redundancies in Edinburgh, 12 redundancies in Newcastle, and 6 redundancies in its Cornwall office, and all of those redundancies were completely unrelated, the change that the government was originally proposing would have meant that an employer had to collectively consult those 20 employees, so elected representatives, or consulted with unions in relation to very small scale redundancies that might be completely unrelated to each other. So that was going to have pretty wide ranging implications. And so the government has pulled back from that, helpfully. So it's going to retain the words at one establishment, but it is going to add in another threshold for considering whether or not you need to follow collective consultation. So it's going to retain the words 20 or more employees at one establishment. So that's going to stay. So if you are looking to dismiss 20 or more employees at one place within a 90-day period, collective consultation will be triggered. But it's also going to introduce a new requirement which says you will also have to collectively consult where you are proposing redundancies which meet the threshold number of employees. Now, as I said earlier, we don't have the detail yet. So what that threshold number of employees is, we don't yet know. It might be a specific number. So it could be 50, could be 100, you know, who knows? It might be a different way of calculating it. It might be a percentage of the employer's workforce, you know, instead of a specific number. So we'll wait and see. There's going to be consultation on that. In fact, the government have said they're going to carry out detailed consultation with all of those people with a stake in good employer-employee relations. So I think that means all of us. So I think we can all expect an email from the government, you know, consulting with all of us because it has an effect on everybody. But we don't know fundamentally what that number is going to be yet. So what it seems to be, though, is it won't have the same one establishment test. So let's say for a minute that the number they introduce is 50. That's the threshold number. If it is 50, then that means that if an employer was proposing to make 10 redundancies in 5 completely separate offices across England and Wales, for example, then the collective consultation obligation would then be triggered. So it's going to be a change to the obligation to collectively consult. We just don't know yet. It could be 25, it could be 50, it could be 100, or it could be some other calculation. So it might be, for example, 10% of an employer's workforce. So let's wait and see. But that is going to be a fairly significant change, because at the moment it's been relatively, it's been possible for employers just to look at redundancies within a particular workplace generally and calculate whether 20 employees are going to be made redundant within that particular workplace. But this is going to change that. The other change, sort of pretty big change that the government is going to introduce, is the protective award. So currently, if an employer fails to properly collectively consult and the representatives of the employees bring claims, they can claim for something called a protective award, which is a penalty against the employer. So it penalises the employer for not collectively consulting properly. And it's 90 days, up to 90 days gross pay, so 3 months gross pay basically, per affected employee. So if you have 100 employees that you are consulting with and you get it wrong and claims are brought, the potential liability is 3 months gross pay times 100 employees. So let's say an average for 3 months pay was £8,000, then times that by 100, I think, is £800,000. So it's pretty chunky, the potential downsides of not collectively consulting properly. What the government is going to do is double that. So they're going to double it to 6 months gross pay instead of 3 months. So if you fail to collectively consult in that same scenario in the future with 100 employees, the potential downside compensation wise would be £1.6 million instead of £800,000. So what the government wants is hoping is that that's going to stop all these unscrupulous employers from doing things like P&O did when they dismissed a load of people and employed a load of agency workers instead. The reality is that most employers don't completely ignore their obligations and fail to consult. Most of the time they try their best. So the government is also committed to introducing some guidance, some improved guidance on how employers should go about collective consultation. So a couple of fairly significant changes there to the collective consultation rules. Again, no actual date for when it's going to come into force, unfortunately, but we'll keep you updated on that. So the second area I wanted to cover briefly was fire and rehire, as the government and the trade unions love to call it. Dismissal and re-engagement is what the lawyers call it, because that's kind of, I suppose, what we would regard as maybe the technically correct term, but fire and rehire sounds better, I suppose. So these changes have really been introduced or going to be introduced as a result of some of the larger employers at times acting in a way which is kind of just trying to force employees to accept detrimental changes to their terms and conditions. So as a result of that, the government has said they don't like the fact that an employer can, if they need to and want to, they can force through changes to someone's employment contract. So if you wanted to change someone's terms and conditions at the moment, how would you go about doing it? Well, first of all, you'd look at people's contracts of employment and you check their contract to see if the employer has the right to make the change without needing the agreement of the employee. So if within your existing contract, the employer can make the change anyway, unilaterally, then you don't need to consult with the employee, and you still need to make a change reasonably and do it in a reasonable fashion, but you might not need to actually change the contract because it might be permitted within the existing contract already. So that's scenario one. Scenario two is you don't have the right to make those changes, so you have to consult with your employees about the changes that you want to make. And so you go through consultation. Sometimes that might involve electing representatives or going through collective consultation, depending on what the changes are. And then hopefully you reach agreement. And if you reach agreement, you can document the changes and everybody moves on. The third scenario is you go through consultation, but you cannot reach agreement with the employees. And what the current law allows an employer to do, provided they have a sound business reason for making the change, and provided they act reasonably and properly consult with employees and try and mitigate the impact on employees, the employer can get to the point where it says, well, we do need to bring these changes in. So we can terminate contracts of employment on notice and offer the employees new contracts to start at the end of the notice period. So that's the fire and rehire or the dismissal and re-engagement bit. So that's worked, I would say, in most businesses pretty well for decades. What the government has said is that if in future an employer decides to do that, so decides to dismiss an employee or terminate their contract because the employee won't agree to a variation, that will be an automatic unfair dismissal. So it doesn't matter if the employer had a good reason for doing it. It doesn't matter if they acted really reasonably. It doesn't matter if they consulted with the employees for ages. It doesn't matter if they offered them some financial incentives to try and help persuade them to agree. It will just be an automatic unfair dismissal with compensation flowing from that. So what the legal test actually says is it will be an automatic unfair dismissal. Bear in mind, there's no qualifying period of service that will be required. So employees from day one will be able to argue that this is an automatic unfair dismissal. Where an employer seeks to vary the employee's contract of employment and the employee didn't agree to the variation, if you dismiss an employee in that scenario, that's an automatic unfair dismissal, or it will be. Or if the employer has dismissed that person with the intention of re-employing them to do basically the same job, but on different terms. So either of those scenarios, that will be an automatic unfair dismissal. The only exception to that rule will be if the employer can show that they were in financial difficulties, and if they hadn't made the changes, they would have probably been in a situation where the business couldn't continue. So in other words, an employer has to be either sort of insolvent or is likely to become insolvent. And if they can prove that, then they can potentially force the changes through, and it won't be an automatic unfair dismissal. But other than that tiny exception, which is going to hardly ever apply in most scenarios, employers will be in that situation now where it will be an automatic unfair dismissal. So, I mean, that is just an absolutely enormous change to employment law. You know, most employers, so this won't apply, this won't just apply in situations where an employer wants to, for example, remove a benefit from its workforce. So it might want to take away private medical insurance, for example. That would be one scenario. If the employer didn't have the right under the contract to take it away, they'd have to consult. And if the employee said no, that would be an automatic unfair dismissal. But it won't just apply in that sort of scenario. It will apply in situations where the employer wants to make any change to a contract. So if an employer wants to change a shift pattern, and they consult with the employees to try and get them to agree to a new shift pattern, the employees won't be any financially worse off. The number of hours might still be the same, but they might want to change the shift pattern in some way. Same thing. If the employee doesn't agree and the employer then dismisses them and offers them a new contract, that will be an automatic unfair dismissal. So the consequences and the ramifications from this are absolutely enormous. So I guess in terms of guidance for you at the moment, remember what I said about the easiest way to be able to change someone's contract is if you have the right under the contract to make the change anyway. In other words, flexibility clauses. So when you are reviewing and updating contracts, you absolutely want to look to build in flexibility wherever you can. Now, unfortunately, it's not that easy. You know, you can't just put in the contract that we can change whatever we want, whenever we want to, and we'll be fine. Courts and tribunals won't allow you to do that because you still have to act reasonably. But overall, it's probably a good idea to look to build in some flexibility into your contracts if you haven't already got it, because that will put you in a much better position then to make changes if you need to, even if you can't get the employees a potential agreement to it. So that's what's coming down the line, the automatic unfair dismissal stuff. At the moment, there is a code of practice. So if you're looking to change terms and conditions at the moment, before the Employment Rights Bill comes into effect, there is a code of practice that the former government brought in July last year. So if you are, I'm not going to go through the code today, but if you're looking to make changes to people's terms and conditions or change their contracts, you do need to look at the code and you need to follow it as best you can. It doesn't really change the law, it's just guidance that you should follow, it's best practice. The consequences of not following the code of practice are, one, that any compensation the employee might get is increased by up to 25%, and two, if you don't follow the code, that would always give the employee a better argument that their dismissal was unfair. So at the moment, obviously, people still need to have 2 years service to be able to claim unfair dismissal, but that is the other thing that's obviously going to change. So under the Employment Rights Bill, as we know, they're talking about day one employment rights. So people will have the right, the likelihood is that from day one, there'll be this sort of preliminary period or probationary period of employment, which might be 9 months. And within that period, if an employer wants to dismiss someone for poor performance or misconduct, for example, they will have to follow a sort of a limited process in order to show that they've fairly dismissed that employee. But that limited process and that probationary period, that won't apply to redundancy dismissals. So in the future, when the Employment Rights Bill comes in, if you want to make some redundancies and you have some people who've very recently joined and maybe circumstances have changed and you need to sort of make some redundancies, you won't, or if you then just dismiss those people who've joined you recently because they haven't been with you for very long, that's going to be an unfair dismissal because you won't be able to just look at the very short-serving people and dismiss them because they've got less than 2 years service, because in the future they will have more they will have day one unfair dismissal rights if the dismissal is for redundancy. So that's another really significant change, because I know a lot of employers that need to make redundancies will often end up, if there have been some short-serving people who haven't been with you for very long and haven't maybe learned the job, etc., you might potentially dismiss those employees and not put lots of other longer-serving employees at risk. That's going to change when everybody gets day one employment right, unfair dismissal rights for redundancy. So another pretty significant change. I'm just conscious of time, so I'm going to leave it there. But if anybody's got any questions on any of that at the end, then please do pop them in the chat function. Tim, I'll hand back to you.
Thanks, Rich. Olivia, immigration, something that I don't dabble in, but you do very well.
Morning, everyone. I'm going to run through a few immigration issues to keep in mind when looking at restructures. Any questions as we go through, please add them to the Q&A function. Firstly, when carrying out a redundancy consultation, an employee's immigration status shouldn't impact on a redundancy process. It's not relevant to the selection criteria. Cost saving is often a reason for a redundancy process, and sometimes employers use it as part of the selection criteria, although it's not the best option. You would need to be very careful not to consider the additional cost of sponsorship as part of the decision making. If you have a sponsor license, you'll be aware that you have certain reporting duties to the Home Office. If you dismiss a sponsored worker for redundancy, then you'll need to report that you're no longer sponsoring them because their employment has ended. This report needs to be made within 10 working days of the end of the employment. And you also need to include their most recent home address, personal email, and phone number in the report. It's also worth bearing in mind that if you are dismissing an employee for redundancy who is sponsored, their ability to stay in the UK is conditional on them keeping their job. So once you've reported that you're no longer sponsoring them, the Home Office will let the employee know that they're cancelling their visa. They'll usually be given 60 days notice in this letter to either get another job with a new sponsor or leave the UK. There can be huge delays with the Home Office actually issuing the cancellation letter, but this is often little comfort to the employee because there's no guarantee when the letter will be sent. It's worth thinking about any ways that you could try to minimise the impact on your employee. So for example, if you were thinking of making a payment in lieu of notice, don't do this because this would mean that their employment is over immediately and you'd be reporting that to the Home Office immediately. Instead of a pile-on, you could put them on garden leave instead, so that it delays when you need to actually make that report to the Home Office and delays the Home Office finding out that their employment is finishing, which gives them those extra couple of months of their notice period to try to find another job. Looking at restructures now. If you have a sponsor license and you're carrying out an internal restructure, which changes certain positions, you need to be mindful of any sponsored employees' roles. All job roles in the UK are given a standard occupation code or a SOC code by the Office of National Statistics. When you first sponsor an employee, you'll have chosen which SOC code their role falls under. And this SOC code was on their certificate of sponsorship and is on their visa. And this is the only SOC code that they're permitted to work under with this visa. If the restructure changes their role so that they move out of the SOC code you sponsored them for and into a different SOC code, then this change is not permitted until you've made changes to their sponsorship. So you'll need to issue a new certificate for the new SOC code, and the employee will need to make what's called a change of employment application, which is essentially for a new visa using the new SOC code. The new visa will need to be approved before the changes happen to the employee's role. So for example, there is a SOC code for care workers and there's another SOC code for senior care workers. So if somebody was moved into the senior care worker SOC code, they would need to make that change to their visa before they could do that. It's worth remembering that when looking at the appropriate SOC code, it's the duties that the employee will be doing that are relevant and not any internal job title that they might have. So if you're just changing the internal job titles as part of your restructure, but the role itself remains the same, then this won't be a problem. It's only when you're making changes to the actual role that you need to be applying for new certificates and new visas. There are some special rules for right-to-work checks following a TUPE transfer. An employer who's found to be employing someone who doesn't have the right to work will be issued with a civil penalty of up to £60,000 per illegal worker. To avoid this, employers need to carry out a right-to-work check in line with the requirements. A properly carried out right-to-work check gives you a defence, which is called the statutory excuse, which means you don't have to pay that fine. As with most other things on a TUPE transfer, the right to work checks carried out by the old employer are deemed to have been carried out by the new employer. This means that you can rely on these, if they've been carried out correctly, to obtain a statutory excuse to a civil penalty. However, that will only help you if the old employer has carried out the checks properly. Generally speaking, a right to work check needs to be carried out before the employee starts working for you to have that defence to the fine. An exception to this follows a TUPE transfer. So the new employer, after a TUPE transfer, is given a 60-day grace period to carry out their own right to work checks. So as long as you carry them out within that 60 days and you've done them correctly, then you will have complete protection from any potential fine for illegal working. Of course, you'll also need to make sure that you diarise the visa expiry dates so that you can sort out any visa renewals and carry out any repeat right to work checks well in advance. If you have a sponsor licence, you'll be aware that you have various reporting duties to the Home Office. Most of these relates to the individuals that you're sponsoring, but some relate to the company itself. The Home Office guidance says that you must report any significant changes to the business. It then lists some examples, but these are only examples of what it considers things you need to report. Some of those examples might occur following a restructure, and those include things like changing your company name or address, or the name or address of any branch listed on your licence. Changes to your company structure, so if you have more branches or sites in the UK or linked entities and you want to add those, then that would be a report that you need to make. If your organisation is subject to a merger, a takeover, or a similar change. If you substantially change the nature of your business. If you stop trading or go into an insolvency procedure. And also if there's a change in size of your organisation. So if you were a large company and now you're a small company, then you need to report that. The definition on this changed last month. So it's possible that you may be a small company now when you weren't before, or if you're carrying out a redundancy process and you're losing employees that way, then that may mean that you're a small employer when you weren't before. Lower fees are appropriate for smaller employers, so it's worth making sure that that is checked and reported on. And these changes all need to be reported in the online system within 20 working days of the change. Finally, I just wanted to talk about what happens to a sponsor licence when there's a merger, a takeover, or a TUPE transfer. The starting point is that the sponsor licence is non-transferable. It only covers the company who applied for it and any branches they choose to list. It cannot transfer to a new business owner. So looking at a TUPE transfer, if sponsored employees TUPE transfer to you, and you will need to apply for a sponsor licence if you don't have one already. You can't use the old employer's licence. You'll need to tell the Home Office that you're accepting the employees who are TUPEing across. You'll need to report the TUPE transfer to the Home Office, and so will the old employer. The employees themselves won't need any new certificates or new visas. They just transfer across to your new licence. If there's a takeover or a merger that isn't a TUPE transfer, then if a company with a sponsor licence has a change in direct owner, then this will usually trigger the need to apply for a new sponsor licence. This feels like a strange thing to do because the same company will be applying for the new licence. So, for example, if company A has a sponsor licence and is owned by 2 individuals and they sell their shares to somebody else, then there's a change in direct ownership of the company. So company A needs to apply for a new licence, but they're still applying for it in the name of company A as they had the old licence. Once they have that new licence, the sponsored workers will just move across to the new licence. There's no need for new certificates and new visas. It's just a report that transfers them across. It's more complicated if those changes in ownership happen further up a corporate tree. So if company A isn't owned by 2 individuals, but it's actually owned by another company, company B, and that company is owned by individuals who sell their shares, there isn't a change in direct ownership because company A is still owned by company B. But there are changes further up the corporate tree, then you'll still need to make reports about changes in ownership, but you may not need a new licence. It's quite a complicated point, which needs to be worked through each time there is a change of ownership. The key point to bear in mind is that if you have a licence and there are changes in ownership of the sponsor licence holder or other companies further up the corporate tree, reports will be needed and possibly a new licence needs to be worked through in advance to assess what's needed and comply with those deadlines. You have 20 working days to make the reports and apply for a new licence if it's needed. So it's just worth bearing in mind that you need to keep that on board when you're looking at changes of ownerships and make sure that you've got time to assess what's happening and what you need to do. Just before I finish my section, I wanted to let you know about some other immigration sessions that we have coming up, which you may be interested in. Tomorrow morning at 10 a.m, we have a webinar on the 2025 Immigration White Paper with a focus on the care sector. So they're the changes that were announced last week, including the potential closure of the skilled worker route for care workers. And then in a few weeks' time, on Thursday, the 5th of June, we have a webinar on right to work checks, which is relevant to all employers with or without a sponsor license. The Home Office has increased its enforcement action on illegal working, is issuing more civil penalties now. So it's a good chance to make sure that you're up to speed with all of the requirements. I'll hand back now for the Q&A session. Thanks,
Olivia. Are we going to put the links to those two immigration online training sessions in the chat? So if you want to attend, please do. There's a lot happening in the world of immigration, as you might have read in the papers in the last couple of weeks. So they will be really informative. Thank you, everybody, for attending. Apologies it overran, and I appreciate everybody who's stayed on the line a little bit longer. And yeah, have a good rest of your week, and we'll catch up with you very soon. Take care.